Cases triable by special judges. The offences punishable under this act can be tried by special judges only. Okay, these judges can be appointed by state government or central government as well. So which cases can be tried by these special judges? These special judges can try cases which is given in this act. Okay, case trial by special judges. Every offence mentioned in section 3 clause 1 shall be tried by the special judge for the area within which it was committed. When trying any case, a special judge may also try any offence other than what is specified in section 3, which the accused may be under CRPC be charged at the same trial. The special judge has to hold the trial of an offence on day-to-day basis. However, while complying with the aforestated, it is to be seen that the CRPC is not bifurcated. So what is given in this means that when trying any case, a special judge may also try any offence other than what is specified in section 3 as well. A special judge may also try any offence other than what is specified in section 3 as well, which the accused may be under CRPC be charged. Okay, so this act will supersede CRPC. This is the thing being said in this section 4 of this act. Means section 4 gives a special judge the power to override CRPC because of this act. Section 5 is procedure and powers of a special judge. The following are the powers of the special judge. He may take cognizance of the offences without the accused being commissioned to him for trial. This is very wide power. Okay, he may take cognizance of the offence without the accused being commissioned to him for trial. Doesn't matter if anyone has reported the crime, he can take suo motu case if he is aware about the offence has been committed in his jurisdiction. In trying, the accused persons shall follow the procedure prescribed by the CRPC for the trial of warrant case by magistrate. Means in the cases where the accused has been framed the offences under this act, the trial will be held as warrant cases, that is given in CRPC procedure prescribed by the CRPC. There are two kinds of trials, as you know that. One is warrant trial, second is summary trial. Third is summon trial. Okay, so what are the procedures can be followed? It is warrant trial. Warrant trial is somehow is harsher. It is more harsh than the summon trials. So to make this act more stringent, this is given. He may, with a view to obtain the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offence, tender pardon to such person provided that he would make full and true disclosure of the whole circumstances within his knowledge or in respect of any person related to offence. There are so many things is given in this line. First thing is that he can take evidence. First thing. Second thing is that person supposed to have been directly or indirectly concerned with the crime. If that particular person is willing to give more evidence, more disclosure about the offence, the magistrate can pardon that particular person. Okay, magistrate has power to bring out the evidences to disclose the act. Except as for section 2(1), the provisions of CRPC shall apply to the proceedings before a special judge. Hence, the court of the special judge shall be deemed to be a court of session, and the person conducting a prosecution before a special judge shall be deemed to be a public prosecutor. Okay, the lawyers who present before the special judge to prosecute that particular accused will be called as public prosecutor. Public prosecutor is defined under CRPC, you know that. The provisions of section 326 and 475 of the CRPC shall apply to the proceedings before the special judge. 326 and 425 of the CRPC belongs to the warrant trial. Okay, so these methods will apply in these cases also. A special judge shall be deemed to be a magistrate. A special judge shall be deemed to be a magistrate, means the powers of the special judge will equate the powers of the magistrate. Magistrate of what? Judicial magistrate, not the executive magistrate. You know that? Judicial magistrate. What is the power of judicial magistrate? He can give the punishment of 3 years maximum. He can try the cases according to the warrant, summon cases as well. Power of CJM, if Chief Judicial Magistrate, is 7-year punishment. He can give maximum 7-year punishment. And power of the above rank of CGM means that ADJ and the district judge is maximum, means he can give capital punishment. There is also one rank. This is assistant session judge. Assistant session judge has power to try for 10 years. Means assistant session judge has power to give punishment maximum 10 years, and CGM is 7 years. A special judge may pass a sentence authorized by a law for the punishment of the offense of which a person is convicted. A special judge, while trying any offense punishable under the Act, shall exercise all powers and functions exercised by a district judge under the Criminal Law Amendment Ordinance 1944. One thing is very important here is given. A special judge while trying any offense punishable under the Act shall exercise all the powers and functions exercised by district judge. Once he said that the powers deemed to be a magistrate, now he is saying that district judge. Okay, go ahead. Power to try summarily. He has also power to try summarily, where special judge try an offense specified in section 3(1) alleged to have been committed by a public servant in relation to contravention of the special order referred, section 12(1)(a) of the Essential Commodities Act. Okay, it is not important. Just go ahead. Offenses and penalties. If a public servant is found guilty, he shall be punishable with imprisonment, which shall be not less than 3 years, but which may extend to 5 years. Means that there is a limit of the punishment. Minimum is 3 years, maximum is 5 years. It is given in chapter 3, offenses and penalties of this act. Okay. Punishment for abatement of offences defined in section 7 or 11 shall be punishable with imprisonment for a term which shall be not less than 6 months, but which may extend to 5 years. Okay, the offences defined in section 7 and section 11 shall be punishable with imprisonment for a term which shall not be less than, there is a English mistake, that word should be shall not be less than 6 months, but which may extend to 5 years. Earlier we read that the punishment will be 3 year to 5 year. Here it is written that if section 7 and 11 comes, the minimum is 6 months, maximum is 5 years. Any public servant who commit criminal misconduct shall be punishable with imprisonment for a term which shall not be less than 1 year, but which may extend to 7 years, and shall also be liable to fine. Shall also be liable to fine. Criminal misconduct done by public servant, which shall be not less than 7 years, which shall not be less than 1 year, but which may extend to 7 years. Habitual committing. Habitual committing means offences which has been committed several times. Habitual committing comes under section 8, 9, 12, shall be punishable imprisonment not less than 2 years, but maximum is 7 years. So in this chapter, chapter 3 deals with offences and penalties. There are certain penalties and punishments. You have read that from 6 months, minimum is 6 months, maximum is 7 years. You have read this. So keep it in mind. That is minimum is 6 months and maximum is 7 years. Investigation is given in chapter 4. Okay, investigation shall be done by police officer not below the rank of inspector if it is a Delhi police, ACP if it is a metropolitan area, DSP if it is an district. So it is an, if it is an district like Bareilly, like any Sultanpur district, any Bihar Muzaffarpur district, Buxar, so where the punishment can be investigated by DSP. If comes to the Delhi, then inspector rank can investigate the matter. If it is a Mumbai, ACP. In metropolitan area it is ACP. Lucknow area, ACP. Okay. What is the criteria to be a city in metropolitan area? You know that it is given that so many acts. If the population is more than 10 lakhs of a city, then that particular city will be called as metropolitan area. But there are a number of cities who has more than population 10 lakhs, but those are not even metropolitan areas. Metropolitan, to be a metropolitan area, government has to pass a special order, an ordinance or any act to make that particular city is metropolitan area. Lucknow was a city till 2017-18, but after that this particular city has been described as a metropolitan city by the UP government. After declaration of metropolitan area, police has more power. You know that means here the police superintendent of police means that SP is the highest rank in any district of police officer. Here SP will be designated as commissioner now. Commissioner is SSP rank or more maybe. So commissioner of police will be the highest rank of this particular city, and this rank will be has more power than any SSP. Means in any district you know that DM is the highest rank officer, and district magistrate can give orders to the SP and SSP as well. But in a metropolitan area, commissioner of police has much more power. He need not to take orders from the district magistrate. You know that. So commissioner has more power. What is the amendment to 2018 of this act? It is very important. As the Prevention of Corruption Act saw limited success in the preventing corruption in government departments and prosecuting and punishing public servants involved in the corrupt practices, an amendment was enacted and brought into force on 26 July 2018. The Amendment Act attempted to bring the Prevention of Corruption Act in line with United Nations Convention Against Corruption 2005, which was ratified by India in 2011. United Nations Convention Against Corruption was held in 2005. India ratified it in 2011. We bring amendment in 26 July 2018 in this act. What are the highlights of the amendment? Definition of undue advantage. The term gratification other than legal remuneration and valuable thing are being replaced by term undue advantage. Okay, so definition of undue advantage is now wider. It includes so many things. When you go through it, through this act, the bill therefore redefines the offence of accepting bribes as obtains or accept or attempts to obtain from any person an undue advantage, intending that in consequence a public duty would be performed improperly or dishonestly, either by himself or by another public servant, is guilty of an offence under section 7 shall be present for a term 3 to 7 years. Undue advantage, section 7, minimum punishment is 3 to 5 years. What are undue advantage? Gratification other than legal remuneration, valuable things, obtains or accepts or attempts to obtain, obtains or accepts or attempts to obtain from any person. Okay. Second term is offering of bribe by person, commercial organization. In addition to treating bribe giving as an offence, here bribe giving is also an offence. Okay, earlier it was not an offence, but now bribe giving as an offence. Section 9 specifically provides for an offence by commercial organization. Commercial organization means any company, any firm. Okay, if any person associated with the commercial organization gives or promises to give any undue advantage to a public servant to obtain or retain business or an advantage in conduct of business, such a person, commercial organization shall be punishable with fine quantum of which not prescribed in the act. फाइन से पनिश किया जाएगा, but the quantum of the punishment is not given in the act. Section 9, who gives bribe, okay, punishment is given. Redefining criminal misconduct. Section 13, the offence of criminal misconduct is specified in section 13 of the Prevention of Corruption Act is being substituted by a new section restricting the criminal misconduct to dishonest or fraudulent misappropriation. A new section restricting the criminal misconduct to dishonest or fraudulent misappropriation of any property entrusted to the public servant, or if the public servant intentionally enriches himself illicitly during the period of his office. Thus, the scope of criminal misconduct has been narrowed in the amendment. So, by this amendment, the scope of this criminal misconduct has been narrowed, and the threshold established, the offence has been increased. Threshold: if the offence has been established, then punishment becomes more stricter right now. I am reading this from the Wikipedia page, that's why I am giving credit Wikipedia page, but not giving no thanks. Thanks but no thanks. Why? Because it is totally copy of the bare act. There is nothing given other than that particular act. Okay. So thanks but no thanks. prior sanction of appropriate government for investigation and prosecution. The amendment extends the protection of requirement prior approval of investigation, prior prosecution under section 17A, except when public official is caught red-handed. Except when the public official is caught red-handed, the police cannot begin a probe. रंगे हाथों पकड़ लिए गए हैं अधिकारी साहब, तो तुरंत पुलिस इन्वेस्टिगेशन कैन बी स्टार्टेड. बट इफ़ रंगे हाथों नहीं पकड़े गए, कोई उनके खिलाफ आकर के मुकदमा लिखवाता है पुलिस स्टेशन में, या कुछ बताता है, कुछ टिप देता है पुलिस को, तो पुलिस कैन नॉट स्टार्ट दिस प्रोब बाई सेल्फ विदाउट द अप्रूवल ऑफ द रेलिवेंट अथॉरिटी और पब्लिक ऑफिशियल. हु विल बी द रेलिवेंट अथॉरिटी? The superior officers of that particular alleged or accused officer. Okay, superior officer जो होंगे उस accused के, वो होंगे public officials. So earlier this was limited to protecting joint secretaries and above. The universal inclusion provides a great deal of protection of honest officials irrespective of their ranks or levels. पहले वाले एक्ट में 2018 के पहले क्या था कि ये सुविधा सिर्फ सेक्रेटरी लेवल के अधिकारियों को दी गई थी, लेकिन अब सारे अधिकारियों को दे दी गई है कि सीधे भैया आप अरेस्ट नहीं किए जाएंगे. आपको अरेस्ट करने से पहले अगर आप रेड हैंडेड नहीं पकड़े गए हैं तो पुलिस को आपकी अथॉरिटी से परमिशन लेनी पड़ेगी. तो एक तरीके से आप समझिए इसमें प्रोटेक्शन दे दिया गया है अधिकारियों को ज़्यादा. इसीलिए कांग्रेस चिल्ला के कह रही थी कि ये तो अच्छा हुआ, हो गया है, और भी अच्छा हो गया अब तो अधिकारियों के लिए, बचाने के लिए उनको करप्शन से, करप्शन के ऑफेंसेस से. फॉर फीचर ऑफ प्रॉपर्टी 18A में दी गई है. टाइम फ्रेम फॉर ट्रायल क्या है? टाइम फ्रेम है 2 साल. अब ट्रायल का मैक्सिमम हो गया है. दिस पीरियड कैन बी एक्सटेंडेड 6 months अप टू द मैक्सिमम 4 years. 6 महीने से 4 साल तक का है टाइम. इन्हांसमेंट पनिशमेंट क्या कर दिया गया? 7 साल तक हो गया है मैक्सिमम, आप जान ही रहे हैं. प्रोमिनेंट केसेस क्या क्या हैं? 2G स्पेक्ट्रम वाला केस था इसमें यूपी गवर्नमेंट में. केतन देसाई वाला केस है, मेडिकल काउंसिल ऑफ इंडिया का केस था जो केतन देसाई का ज्ञान सागर मेडिकल कॉलेज का था. इसमें क्या किया गया था? द CBI रिसेंटली अरेस्टेड द मेडिकल काउंसिल ऑफ इंडियाज फॉर्मर प्रेसिडेंट केतन देसाई एंड 3 others अंडर दिस एक्ट for allegedly accepting a bribe to permit Patiala-based Gyan Sagar Medical to recruit a fresh batch of students without having adequate infrastructure. तो केतन देसाई जी को अरेस्ट किया गया. क्यों अरेस्ट किया गया? उन्होंने जो है ज्ञान सागर मेडिकल कॉलेज को परमिशन दे दी थी कि आप स्टूडेंट्स की भर्ती करना शुरू कर दीजिए विदाउट एनी प्रॉपर इंफ्रास्ट्रक्चर. थैंक यू.